Welcome to Absolute Trust Counsel's new webinar series about estate planning basics, not about what you have, but about being prepared. My name is Madison Gunn. I am an attorney at Absolute Trust Counsel in Walnut Creek, where we offer estate planning services as well as trust administration, special needs planning, probate, and everything estate planning related. I am going to share my screen because we always have to tell everybody that when we're doing it. Please feel free to ask questions. There's a chat and there's a Q&A. Please feel free to put them in there and I will see them as you put them in and answer them either at the end or depending on the question or as we go if it's relevant to that particular slide. So thank you. So to begin, we're going to go over an overview of estate planning. So the word estate, it conjures up something from Downton Abbey, rolling green acreage, but it's really just a legal term for money or assets, no matter how big or small. So estate planning is not just for the rich. It's not a trust fund baby situation where everyone's got millions of dollars and you come from old money. It is not like that at all. And so we want to debunk that myth. Estate planning is really about doing what you want to do with what you have and ensuring that your wishes are carried out, even when you're no longer able to communicate, either due to incapacity or death. It's also about planning around the local laws to ensure that your family is not burdened by the requirement to involve the courts and the delays that can cause and costs that the courts cause. So we want to avoid that crisis mode and interruptions in care by having the right documents set up for individuals so that we don't have to ever go through the court. Even an emergency court process is not a quick process. Okay, so the first part I'm going to talk about is incapacity planning. And we're going to talk about this a few times because it's very, very important. If somebody dies without an estate plan, the law has a plan in place, whether it's your plan or not, I don't know, but there is a plan. If you become incapacitated, the only plan is a conservatorship. So it is very important that we plan for incapacity planning. And I will point out that anybody over 18, even if you don't have any assets whatsoever, needs an incapacity plan. If your daughter who just went off to college has an accident and is in the hospital, no one's going to be able to make decisions for her if she doesn't have an incapacity plan in place. So in an incapacity planning, you can define what incapacity means. You can determine who determines incapacity. You as an individual in your documents can determine who determines incapacity. It provides for topics for you to discuss with your family as to what your wishes would be, and obviously help provide access to documents for your family. So I talk about determining incapacity and who gets to determine. In most estate planning documents, there is a default mode of saying that a note from two doctors or two doctors' letters state that you are no longer able to manage your finances due to health reasons. You can change that default in your estate planning document, typically a trust or a power of attorney, and decide who gets to determine your incapacity. So if it's not planned for, like I mentioned, an alternative is a conservatorship, which anybody in your family can petition for, and there can be competing petitions and fighting. So we try to avoid all of that with having these documents in place. So you can say who gets to determine, your incapacity. And the way we talk about this with our clients, because what we've seen before is that if somebody has an acute illness or a stroke, you're going to be in the hospital. Two doctors' notes is not going to be difficult. However, if somebody is seeing some cognitive decline with age or possibly dementia or Alzheimer's, and it maybe hasn't been diagnosed yet, but they're not able to manage their finances, it can be very difficult to get two doctors' notes stating that they are unable to manage their finances. Sometimes because doctors are just unwilling to provide that. They don't want to take on any liability that might cause. In addition, if you've known your doctor for a long time, it's pretty easy for somebody with dementia to present just fine to that doctor, especially when you're talking about memory and cognition. And then on the flip side, most people like me see your doctor for 5 minutes a year. So they're not going to necessarily know your personality. Unless somebody is very far gone into dementia or Alzheimer's, then it might be obvious. But it's that initial, initial decline where you might present fine in public, but you haven't opened your mail or paid a bill in 6 months. And those are the things that are important, to making sure that you have a plan so that you don't default on your mortgage or not pay your electrical, things of that nature. And as I mentioned, the alternative is that conservatorship, which is very costly. It's sent out to every relative to your second degree. To the second degree, it involves everybody, and it can get quite messy. We like to avoid this. So the main component in California that we use for estate planning is a trust. And a trust is just a document that explains, has all the legal language in there that makes it a trust, and it's considered a revocable trust or a living trust. It is a mechanism in California that allows individuals to avoid probate. So it does everything that most people envision a will to do. It leaves everything to whomever you'd like to leave it to. It can hold things in trust for minor children, assets in trust for minor children. It can give specific gifts to charities, all the things you would think a will could do. But the reason why we wouldn't use a will in this case, and we would want to use trust, is that in California, dead people cannot own real property, which is land or a home, that's worth more than $50,000, or in total, any assets that total up more than $184,500, that's 2023 numbers. If you have more than that, that doesn't have any type of beneficiary on it, then a probate is required. And a probate is the court supervised process in which your assets would be distributed, and it costs, a nice chunk of change that you probably don't need to pay. So with a trust, the trust is like a basket. It's its own entity. It's a document, and you can pick and choose what goes into the trust. So you plan for your trust assets on both your incapacity and your death. You can plan what assets go into the trust. You can control beyond death to an extent, like having assets held in trust for minor children or grandchildren. You can decide who will manage the trust, both while you're incapacitated or after you die. It can be different. And it avoids that conservatorship and probate for incapacity and death, and it avoids frozen accounts and crisis mode. So it's a fairly smooth transition, to your, what we would call a successor trustee, who's going to take over when you are no longer able. The beauty of a trust, and I'll point out a revocable or living trust, is that you get the entity protection against probate. It's this document that you create that's treated as an entity to protect your assets from probate, but it's not an entity for tax purposes while you're alive. So you still have control of your assets. You create the trust, you're the beneficiary of the trust during your life, and you're the trustee of the trust. So you have complete control over your assets while you're alive. You file your taxes normally. There's no change for you on the day-to-day. Will. So I mentioned a will in that most people understand a will is what you would use to leave your assets to somebody. In a foundational estate plan using a trust, a will is you still have a will, but it's a specialized will called a pour-over will that leaves everything to your trust. The trust does all that heavy lifting, and the will is just a supporting document. So if you don't have a lot of assets and you just have a simple distribution of maybe your personal property, then you might need a will-based estate plan as opposed to a trust-based estate plan. These are all important things to discuss with your attorney when deciding between the two, because sometimes a trust is just a lot easier, especially in terms of incapacity. So a will also nominates a guardian for minor children and is there for those small estate affidavits or simpler probate items that may not take as long, typically the ones that don't go. So a power of attorney. The power of attorney is an incapacity document. It's only good while you're alive. The trust covers your incapacity as it relates to trust assets, but it does not cover non-trust assets. So that is where your durable power of attorney comes into play. Who you nominate as your agent under your power of attorney will be able to use the document to speak to your employer, retirement accounts, Social Security Administration, any legal matters you have, landlord-tenant issues, facilities you might live in, like an assisted living or even an independent living, same landlord-tenant issues, and all financial matters. If you have a leased car, that would not be an owned asset, so your power of attorney could speak to the car dealership. Everybody should have a power of attorney. Everybody over 18. The other part of the incapacity duo that we like to use is an advanced healthcare directive. So an advanced healthcare directive is a combination of a living will. In some states, they call it a living will, which is actually an outline of your wishes, what you want to happen in certain situations. Do you want your organs donated? Do you want to authorize an autopsy? Do you want to be cremated? Decisions of that nature. And so that's a living will. And then a power of attorney for healthcare names who you want to make those decisions for you when you are no longer able to make decisions for yourself. So an advanced healthcare directive is a combination of those two documents. It's one document, lays out who gets to make decisions for you, and lays out what your wishes are for your agent if you are unable to communicate those wishes to your agent yourself. And then we also do what's called a HIPAA waiver, or Health Insurance Portability and Accountability Act, which is a federal law from 1996 that creates national standards to protect sensitive patient health information from being disclosed without your consent or knowledge. So this is a consent form that allows the individuals that you nominate as your healthcare agents to be able to receive that sensitive health information so they can make educated decisions. We want to eliminate any hurdles that you might come across in the hospital when someone's trying to make medical decisions for you. We discuss the trust as an entity, and putting assets in your trust, you get to pick and choose. So we call this funding, and that is the actual putting of the assets into the trust. And the way this works is through retitling. So if you have a home, I might own that home as Madison Gunn, a single woman, or a married woman with my husband. If I'm putting it in my trust, I would then transfer it to myself via a deed through my attorney to transfer it into the Madison Gunn Trust with me as trustee. So it's just a change. It doesn't change the actual ownership because I still own it. I just own it as trustee of my trust. So typically your estate planning attorney would handle deeds for you, but it's important to look at any refinancing, inheritances, or new purchases. Once you have an estate plan in place or a trust, you want to make sure that if you refinance, they don't make you sign a deed taking it out of your trust, or if they do, you have to make sure that there's a deed putting it back into the trust. That's becoming less and less common as lenders realize that these revocable living trusts are still normal lending practices to individuals and not to an entity. Inheritance, if you receive an inheritance, a property, you can put that right into your trust. Same with money. If you have a trust account, you can put any inheritance right into it. And any new purchases you can buy right in the name of your trust. Any financial accounts you have would need to be retitled. So you'd have to go to the bank or contact your financial advisor to make sure that they retitle the accounts in their system, whatever that might look like, into the name of the trust. Same with stocks and bonds. If you have certificates, you have to have them reissued in the name of the trust. Same with bonds, although you can register them online. That might make things easier. Any businesses you own, you can assign your interest to the trust. If it's a sole ownership, you can do that right away. If you own it with somebody else, most attorneys would want to look at your business formation document as to what you're allowed to do or what the procedure would be. Cars, you typically do not have to title in the name of your trust. In California, we have our simplified DMV procedure that you can use instead. Typically, because cars are so transient, you don't know. I'm certainly not going to own the car, I hope, that I own now upon my death. So same with most individuals. And then I made a note of power of attorney with banks. So we typically an attorney would draft a power of attorney for you as a part of your estate plan, but some banks like to have their own power of attorney on file for you. So that might mean when you go in to make sure that your accounts are in your trust, if you're leaving any accounts out of your trust, you might want to fill out a power of attorney with your bank that matches power of attorney that your attorney drafts for you. And then a failure of putting your assets into your trust or a failure of putting a beneficiary on your account could result in probate. So we discussed earlier that the $184,500, which is the current if you die in 2023, if you have more than that, that is outside the trust or nobody has access to because there's no beneficiary on, then that would have to go through probate. Okay, beneficiary designation, because I'm imagining everybody out there saying, but wait, what about a beneficiary designation? Does that have to go through probate? So if you have a beneficiary designation on your retirement account, they are not subject to probate. They don't go in your trust. But you do want to make sure that you have a proper beneficiary designation. You want to make sure they're up to date. You want to make sure they match what's in your estate plan. If especially your estate planning goals, it may not be the same beneficiary you name in your estate plan, but you want to at least discuss it as a whole with your estate planning attorney. And you want to make sure that your life insurance has a proper designation as well. There are tax implications for retirement accounts to discuss with your estate planning attorney. And there's also implications if you have minor beneficiaries. What's that? You want to make sure they're correct, and then you want to make sure that they get updated upon divorce, the death of a beneficiary, anything, major life event, people are born, things that are going to affect your estate plan. You want to make sure your beneficiary designations are up to date. There are times when naming your trust as a beneficiary might be a positive idea in order to make sure that you don't result in a no beneficiary on your retirement account, because if resulting in not having a beneficiary or a live beneficiary on your retirement account could go two ways. Either that retirement company, whether that be Schwab or Fidelity or whoever holds your retirement account, has their own rules as to who would get that upon your death, or it goes to probate. And if it goes to probate, it gets liquidated all at once. So there's really no opportunity for anything for those beneficiaries because all the taxes are going to be paid right away. So those are just as important as the actual trust document itself in terms of your estate plan. Common estate planning questions that we receive. They seem simple, but they can actually get pretty detailed. So one of them is jointly owned real estate. So before I jump into why that may or may not be a good idea, I want to discuss the difference between joint tenants and tenants in common. So if you see a deed that says, Mary and Tom as husband and wife as joint tenants, that means that they both own 50% together. And that joint tenant means that there's a right of survivorship, meaning if Mary dies, Tom owns the full house and vice versa. Tenants in common, which sometimes it might say that, Mary and Tom as tenants in common, or more commonly, if it just says Mary and Tom, husband and wife, and it does not say joint tenants, the default in California is tenants in common. And this means Mary owns 50% and Tom owns 50%. So if Mary dies, Tom has to probate Mary's 50% if it's just in her name, and vice versa. So it's important to take a look at how you own your real estate and how you vest on title when you buy property, because especially if you own it with other individuals, maybe not your spouse, but you're buying an investment property, you want to make sure that it's vested properly so that if somebody dies, you don't end up having to file a probate and waiting a couple of years just to get their name off title. Or if they don't have an estate plan, you might be a co-owner with several people that you didn't intend to own property with, or minors, which could be a bigger issue. So it's very common for individuals to ask that, hey, I'm getting older for my estate plan, can I just add my child onto my house? You certainly can do that. It's not illegal. I don't advise it in all situations. In California currently, under Prop 19, if you were to add your child onto your house as a part of your estate plan and they don't live there, then the house is going to be reassessed for property tax purposes. So if you've owned your home for a long time, that's probably not an ideal situation. Additionally, it's a gift. So anytime you add someone onto your home, it's considered a gift to that person. So if it's your child or anybody else other than a spouse, that gift you have to report to the IRS through a tax filing. You may not have to pay taxes on it, and your child wouldn't have to pay taxes on it, but you have to report it. Additionally, that means that even though you're doing it, putting them on the title with you with the intent to make for, after you die or you become incapacitated, that asset is still viewed as that child's asset or whomever you're adding on title as soon as you do it. So if they're trying to apply for Medi-Cal and it looks like they have a second home or anything or trying to apply for a mortgage, it looks like they already own a home or they're getting divorced, that's an asset that's considered theirs under the law. Even if that's not your intent, and your intent is for them just to receive it upon your death, putting their name on it while you're alive gives it to them while you're alive. Same thing for joint accounts. So, a lot of times people want to add their children onto their bank accounts for convenience so that they can write checks for you if you become incapacitated. Same thing. So they become a joint owner of the account. You're gifting them the assets of the account that requires a gift tax return to the IRS. You are liable. So if they get sued, that asset is available to them, even if they didn't put money into it. So same with your home. If they're getting a fender bender and get sued or have a gambling problem and have to pay up, they can go after those assets that are in joint tenancy or joint account. So we don't typically advise. I mean, there's some situations where it's not that big of a deal, but we don't typically advise doing that. A trust and a good power of attorney covers all of that without having to be joint owners. Okay, so now your estate plan has been established. And the big questions are, when do you update it? Do you set it and forget it? Or do you have to go back and look at it? We advise, dust it off every year or so, make sure it looks good to you. But otherwise, the big times to change it would be if there's changes in the tax laws, which hopefully your estate planning attorney reaches out to you, puts a post on social media, something that there's a change in the tax law that might affect you. If there's changes in family, obviously birth and death affect your estate plan. Changes in assets, not necessarily because you acquired assets, do you need to update your estate plan, but you might. So if you acquire a house and you want to make sure that house goes to a particular child, you would want to write that into your trust. If you have your current estate plan leaves the house to one child and the rest of the assets to the other, and you sold that house, you might effectively be disinheriting that one child. So you might want to make an update. So changes in assets, if they're listed or need to be listed in your trust as a distribution, you would want to update. Changes in fiduciary. So a fiduciary is who would be your trustee or your power of attorney. That person has what's called a fiduciary duty to you or to the beneficiaries of the trust. If you want to change who's going to manage your estate plan after you die or during your incapacity, then you would want to update the estate plan. So if somebody dies, they're as old as you are and you're aging and you're worried about it, or maybe you've decided that somebody isn't as responsible as you thought they might be, you go in and update them. And then changes in living situation. As people are moving out of California, you might want to update your estate plan to be compliant with the laws of the state that you're moving to. We advise reviewing regularly, like I said, dust it off. If you need to get a summary of it from your attorney, one of the things we offer is a little one-page schematic, so you can at a glance see who's getting what in your trust document, and then a summary page with who would be acting on your behalf in all of those different documents. So you don't have to go through and read your binder. unnecessarily. Although I do advise reading through it, there are summaries that you could take a look at and make sure, and then talk to your attorney. Have a quick meeting, go over, make sure nothing's changed. Attorneys usually have a set of questions that they're going to ask you in order to see if you need to make updates that might, trigger thoughts in your mind. All right, I am going to minimize the slides, I think, for a minute and answer some questions before I finish up. Does anybody have any questions that they want to submit? I'm happy to answer. Go ahead, Harvey.
I want to know, what do you recommend as beneficiaries to an IRA? I have a trust.
Yeah, that's a good question. So your beneficiaries for your IRA might match your trust. So if you have a trust with a spouse, your spouse would be most likely be the beneficiary of your IRA. If you have children, they could be the beneficiary of your IRA. If you are worried because your children are little, then the trust might be a good beneficiary for the IRA. It depends on your specific familial situation.
So you do not make the beneficiary the trust, though, do you?
Not necessarily at first go. You might have a couple of layers of beneficiaries before the trust is the beneficiary of the IRA. And just to clarify, we don't retitle the IRA into the trust because the tax benefits and breaks that you get as an individual for having an IRA or a 401k is only because you're an individual. So if you were to retitle it in the name of the trust now, you'd have to pay taxes on all of it now, which that's not what anybody wants. But depending on who the beneficiaries of your trust are, you could name the trust as the beneficiary of your IRA, or you can just name the beneficiaries you have listed in your trust as the beneficiaries of your IRA. It depends on how complicated it is for you.
Thank you.
You're welcome. I'm going to go back to my screen and just discuss what we can do for you. So I just want to let everyone know, I gotta stop using the word advise, let everybody know that we have a podcast, Absolute Trust Talk. It's available wherever you receive your podcast, iTunes, all those, I don't even know because I just have an iPhone. And on our website as well, absolutetrustcounsel.com. You can access them all there. You can watch them if they are on video on our YouTube channel. You can have a free discovery call if you give our office a call or schedule a discovery call on our website. And this is set up to see if we can help you. And then typically we have a free consultation to go over what we can do for you. And then we have a ton of free resources on our website. So we have a bunch of guidebooks that are specific to certain situations for estate planning, talking about wills, trusts, incapacity, Medi-Cal issues, trust administrations, like what happens after you pass away, how does your successor trustee manage your trust? There are a bunch of downloads and guidebooks that you can receive through our website. So we strongly advise going there and accessing those free resources. And if you need more assistance, please schedule that discovery call with our office. I do believe we're going to be having more of these. So if you have any friends or family that you think would benefit from this, particularly if you have older parents that don't have an estate plan, I strongly encourage you to sign them up so that they can watch our next webinar and we can answer any questions that they have. But we want to be here for all of your estate planning needs and assist you. And of course, like I mentioned earlier a few times, incapacity planning is one of the most important parts of estate planning. And so we strongly advise, as soon as everybody turns 18, to have a power of attorney for finances and an advanced healthcare directive power of attorney for medical decisions. It's just good practice. Even if you're concerned about assets or beneficiaries, this doesn't apply to that. It's just to make sure that somebody is named to act on their behalf. Oh, I do have a question. Woohoo! Are there different trust structures if you have one spouse with assets before the marriage that you would like to follow familial bloodline? So yes, there are different trust structures. And the next question says, can you talk about a estate plan that has a Part A and Part B? And I think that means the same thing, but please correct me if I'm wrong. So there are trust options for you for marital structuring that can make sure that some assets bypass a spouse and go directly to, children, especially if it's your separate property. Obviously, confirming that it's your separate property is always good, which is a whole other topic. But there are also structured trusts where the trust splits in two upon the death of the first spouse, and part of it becomes irrevocable, and that is the deceased spouse's trust, and the assets are preserved, typically for the beneficiaries after the second spouse dies, and then the surviving spouse can manage their own trust as they need to. So there are definitely different trust structures, and I would advise speaking with an attorney to see what works best for you and your spouse. But yes, absolutely, you can plan for all of it. The great thing about a trust is that you can, customize it and structure it the way you need to. There are plenty of times that we go outside of the normal trust structure in order to make something work for a family. Did I answer that second question about part A and part B? I think that's what it means. Sometimes they call it trust A and trust B, or a survivor's trust and a bypass trust.
I have a question regarding Prop 13 and 19. I was wondering if I have a partner, but we're not married, and she's concerned about the fact that Prop 13 is going to be reassessing our property should I pass the property on to her. Is there a way to avoid that?
There are ways to avoid it. Typically, it's the exemption to Prop 19, or with the reassessment of a property. It's really an exemption to what's called a change in ownership. So when somebody dies that owns real property, it changes ownership to whomever the beneficiary is. And spouses are exempt, so it's not considered a change in ownership if it's going to a spouse. And children and grandchildren are exempt under very specific circumstances. If she is not on the house with you now, it would be reassessed. But it would also be reassessed if you added her now. So it might be something a little more complicated to look at, but in general, yes, if she inherited the home from you, it would be reassessed for property tax purposes.
If she's living with me, and I decide that we're marrying her or having a domestic agreement or whatever you call it, help avoid that. And how much time is there required for us to have that happen?
Yeah, if you're married or have a registered domestic partnership, it would not be considered a change in ownership. So there would be no reassessment. And as far as I'm aware, there's no time frame required. Like, you don't have to do that a certain time period in advance in order for it to qualify.
So if you get married the day before you die, that's okay.
If your estate plan's leaving everything to her, yes.
Okay. Thank you.
Does the reassessment still happen if you are joint tenants not married? No. So under joint tenancy rules, it is not considered a change in ownership in that way. There's no reassessment because there's that right of survivorship on the joint tenant. If you're already joint tenant, they're coming through. How can children and grandchildren be exempt from an inherited property tax? Great question. So under the new Prop 19 rules, children and grandchildren are exempt from reassessment if it is a parent leaving the parent's primary residence to a child or children, and at least one of the children then moves into that property, making it their primary residence. They get to keep that exclusion from reassessment until it's no longer their primary residence. So that's for children, and it's limited to $1 million in assessed value increase. So if your home is currently assessed at $400,000 on your tax assessment, and its fair market value is $1.4 million, then it's fine. There'll be no reassessment. If it's worth more than $1.4 million, then the difference, whatever over $1.4 million it's worth, will be reassessed for property tax purposes and added back on to $400,000. So essentially, you get like $1 million off. Like, you get the $7,000 off for a homeowner's exemption if you look at your tax bill. For grandchildren, there's a very, very specific set of circumstances. So grandchildren are excluded from reassessment if they're treated like children, meaning their parents are deceased ahead of time. So if you have a grandmother that passes away and leaves everything to her grandchild that she raised, but the daughter is still alive in there, or the father is still alive and they were married at the daughter's death, then that would not count. However, would create a reassessment. They would not get the exemption. However, if a grandmother dies and leaves the house to the granddaughter where the daughter was deceased, the mom of the granddaughter, and either her parents weren't married at the time of mom's death or dad is also deceased, then that granddaughter would get the exemption from reassessment under the same terms as the child. So it has to be their primary residence for both of them, up to $1 million in exemption.
I wanted some clarification. Yeah. What if the house is worth $2 million?
So it depends on what your assessed value is. So if your assessed value is $400,000 and it's worth $2 million, then you get $1.4 million in exemption from reassessment, and the $600,000 is going to be reassessed. So essentially, you're going to go from a $400,000, assessment to $1 million assessment, because you're going to add that $600,000 on. So it'll be reassessed for $1 million home instead of a $2 million home.
Thank you.
Mm-hmm. Thank you for choosing a whole number. That worked out perfectly. All right. If anyone has any more questions, like I said, feel free to contact us at Absolute Trust Counsel. You can give us a call, send us an email. You can schedule a free discovery call or take a look through all of our free resources. Thank you so much for coming. Please tell any friends or family that need an estate plan or just have questions about an estate plan. They might not think they need it. That's very common and understandable. So these are free webinars that we offer. So anytime anyone has questions or just needs a little general overview of what you might be talking about, then we're happy to accommodate, and we'll post more promotions in the future. Thank you so much for attending. I really appreciate it, and I hope you learned something and enjoyed it, and that you're not all sleepy. All right. Thank you, and take care, and have a good day.
If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling.